In this series of vodcasts, we're going to continue on that focus on contract, but we're going to move from formation of the contract to start looking at whether we really have a contract that we think has been formed, what's in that contract, and also what happens maybe if one of the parties breaches one of the terms of the contract. So let's pop into it and remind ourselves of how this all fits together. Remember that we're concentrating here on a series of 5 questions across the 2 weeks. We've looked at what actually is a contract and how we make a legally enforced contract. So we're now going to concentrate on when a contract might be unenforceable. So it looks like we've got a contract, but we actually haven't. What the terms of the contract are, and what happens if we don't honour those terms. So the first thing we've got to do is look at what we mean by consent, right? Because you'll remember that the key to a contract is about the meeting of minds. And the meeting of minds can only occur when the parties truly consent to the terms of the contract and to being bound. And there are some times when there might not be true consent, even though it looks like we've got agreement, intent, and consideration. Okay, once we've made sure that we've got this meeting of minds, we've got to agree what the meeting of minds was about. What were the contractual terms? And we want to distinguish contractual terms from non-contractual representations. We're going to just briefly discuss the special case, a special type of term, a disclaimer, and how they're read a little bit differently to most other terms in a contract. And then finally, we want to be able to distinguish between a condition and a warranty. Now, these are both terms in a contract. Okay, so they're both part of the contract, but the effect on the remedy is quite different. Okay, so if you breach a condition, there's a different outcome that you can get rather than if you breach a warranty. So we need to be able to distinguish between a condition and a warranty in terms of the terms of a contract. So let's start by looking at consent. Now you'll remember we've crossed off the essential formation, the simple apparent contract. And to get a simple apparent contract, we need agreement, intent, and consideration. Now if we have that, it looks like we've got a contract. But what happens if something else is lacking to mean that we didn't have a true meeting of minds? We might not have a true meeting of the minds where one of the parties don't have capacity to enter, where the objects or the subject matter of the contract is illegal, where the law isn't going to allow a contract. We're not going to deal with those. We're going to instead concentrate on consent. That's likely to be the one that we run into. What happens where someone didn't really consent to the deal that they've ended up in? When will the law say you didn't truly consent? So as this diagram shows, there are actually 4 types of situations in which consent may be lacking. We're only going to deal with 3. Why? Well, it is possible to lack consent due to a mistake, but this is actually quite rare. And it's quite a detailed area of law. So we're going to give that a skip because we probably won't run into that in the real world. What we might run into though are cases involving duress, and that can be physical duress or economic duress, undue influence, and unconscionability. Now all these situations involve in some sense one of the parties not truly agreeing to the deal. Some other force has acted on them to get them to agree. That lack of consent means that one of the parties hasn't entered into the contract willingly. They could have been bullied, pressured, manipulated into entering the contract. And so that's where the focus on duress, undue influence, and unconscionability comes from. The case we want to deal with is Barton and Armstrong. So what happened in this case was we had an individual who was involved as a shareholder in a company, and he was also a director, one of those people running the company. And there's been a long history of fights between parties, not physical, but tensions and ill will between the parties over who should control the company. And Armstrong had actually been the most aggressive. In fact, several directors had asked Armstrong to resign as a director, and he refused. And in the end, Armstrong threatened Barton. He actually made death threats. He actually said, if you don't purchase my shares at a greatly higher price than what they're really worth, I'm going to kill you. So, of course, Barton said, okay, well, I'll buy it because I don't want you to kill me. And what the court held here was that the death threats were sufficient to show Barton hadn't consented to the contract. Even though he entered the contract, and he might have entered the contract anyway, the death threats contributed to the decision. And so the contract was set aside. Okay, so that's duress. It's also important to recognize that duress can be about your physical presence, death threats, I'm going to hurt you. It can be threats to your property, or it can be what's called economic duress, which is where people are threatened to take away your livelihood, etc. So our next case, Johnson and Buttress, is subtly different. In this case, Johnson has looked after Buttress for several years. Buttress had been illiterate and wasn't very worldly in business affairs, and so Buttress had relied on Johnson. Now, Buttress then transferred some land to Johnson. And in fact, there was some evidence to show that Buttress didn't really fully understand that they were transferring the property permanently. So Buttress dies, and then Buttress's son tries to get the land back and actually contested this transfer of land. Now, the court held in this case that even though Johnson hadn't pressured Buttress into transferring the land, like there was no duress, the nature of the relationship between them was such that Buttress had trusted Johnson. Okay. And so in that situation, the law presumes that Johnson is going to exercise something called undue influence. So there's no duress, right? No physical pressure, no pressure on property, no economic duress here, but there's a relationship such that we would presume Johnson had used undue influence, and Johnson, has to be able to show she didn't use undue influence, and she couldn't do it here, and so the transfer was set aside. Our final case here around consent is a very famous one, the Commercial Bank of Australia and Amadio. So what we had in this case was an elderly Italian couple. They were migrants, Mr. and Mrs. Amadio, who had limited English, little formal education and no business experience. What they actually did was sign a guarantee with the Commercial Bank of Australia. They were guaranteeing the debts of their son's company. The son had advised them that the guarantee was limited to $50,000 for 6 months. The contract wasn't in fact limited to $50,000 or 6 months. The bank manager had gone into the Amadio's house and into their kitchen, and he gave them the contract and said, sign immediately. When they mentioned the 6-month period, he corrected them, pointing out it was indefinite. But they relied on their son and they signed the contract. Of course, the son's company goes bust, goes into liquidation, and the bank demands their payment, which required the sale of their house. So the issue here is, was there true consent from the Amadios? Did they really know what they were signing? And it was held here that the bank manager had acted unconscionably. Okay, so this is unconscionable conduct. Okay, now to have unconscionable conduct, we actually have a number of conditions that actually have to be put in place. First, one of the parties must have to have a special weakness or disadvantage. Okay, so here it was that they were an elderly Italian couple with limited English. 2, the other party must know about that or should know about that, and that was pretty clear in the interactions with them. And 3, the other party must take advantage. Okay, takes advantage. Now, if those 3 conditions are met, we have unconscionable conduct. And that's what we had in this case. The Amadios had a special weakness. The bank manager knew or should have known about that, and the bank manager took advantage of their limited English and lack of experience in this matter. So in all of these instances, what we're saying is that the parties really haven't freely and willingly entered into the contract. And if we have that, then what we can do is the weaker party, or the party who hasn't truly agreed to the contract, can make the contract unenforceable. So it's as though they don't actually have a contract. Just to reiterate, duress is where one party compels the other to enter into the contract by threatening harm. That harm can be personal safety, the safety of goods or property, or the economic or financial well-being of the other party. The second case of lack of consent is undue influence. Now, in undue influence, we have a pre-existing relationship, right? That's critical. You can only have undue influence where there's a pre-existing relationship, where one party has influence or dominance over the other. And then they use this influence such that the party is not really exercising independent judgment. Now, what happens is there's 2 situations. The first situation is that in some relationships, it's presumed that you have this influence. So, doctor-patient, lawyer-client, trustee-beneficiary, parent-child, religious leader-follower. So you can see this issue of one party being able to take advantage of the other party. There's a kind of fiduciary relationship here. Now, if we're in one of these relationships, it's presumed you have undue influence. In the second case, there are other relationships where you actually have to show that the other party had the influence. Okay, now, if it's this kind of presumed relationship, then the onus is on the stronger party to show that despite that relationship, they didn't exert the influence. If they can't, the contract is void. When the relationships is not one of these presumed, the weaker party has to show the other party did have that influence. And that's what happened in Johnson and Buttress, right? There wasn't this presumed relationship. They actually had to show the other party had influence over them. If the weaker party shows this first, then the stronger party has to show that they didn't use that influence. Okay, so it reverses this idea of who's got to prove what. Finally, unconscionability. A contract can be set aside when one of the parties has a special weakness or disadvantage. Now notice the difference here. In undue influence, there's a pre-existing relationship where one can influence the other. In unconscionability, there's no pre-existing relationship. What we have is one of the parties who has a special weakness. The other party knows about it or should know about it, and then they take unfair advantage of that. That's unconscionability. It's also been incorporated into consumer law, and we'll just touch on that next week. Okay, so that covers off consent. We're now going to move on from saying, okay, well now we really do have a contract and we want to work out what's in it by looking at what are the terms of the contract.